Emma Mijas died a horrible and painful death unnecessarily on her very first Christmas Eve 2004 at the hands of 25 doctors and nurses, another victim of medical malpractice. All 25 doctors and nurses systematically administered the wrong drugs for her life-threatening condition called SLOS. SLOS, Smith-Lemli-Optis syndrome, is a congenital abnormality which requires treatment strategies on supplying supplemental cholesterol. They gave Emma the wrong drug, Questran, not once, but 92 times. Yes, 92 times in 1 month. A cholesterol-reducing drug, not the cholesterol supplemental drug she needed. All of them knew better. They were trained to know better. They were some of the world's leading authorities at the Louisiana State University Health Science Center in New Orleans. But they just didn't give a damn about Emma's life. In 2013, the prestigious Journal of Patient Safety published a study that as many as 440,000 patients die each year from preventable medical errors. That would make medical errors the third leading cause of death in America, behind heart disease and cancer, which is second. These people are not dying from the illnesses that caused them to seek hospital care in the first place. No, they are dying from mistakes that hospitals could have prevented. What are these fatal errors? Who are these incompetent and negligent doctors? A New England Journal of Medicine, January 28, 2016 study reported that 1% of physicians accounted for 32% of paid malpractice claims over the last 10 years. The ugly truth is that little is being done to hold these dangerous doctors accountable. Researchers found that bad doctors showed distinctive characteristics, including having paid previous malpractice claims. So it stands to reason that healthcare providers could eliminate 1/3 of medical malpractice along with patients' pain and suffering, as well as the added cost of corrective surgeries, long-term care, and indemnity payments by removing the worst 1% of doctors. Why aren't bad doctors stopped from practicing? The answer lies, at least partially, in the National Practitioner Data Bank, a clearinghouse for information on medical malpractice that Congress established in 1986 to help state licensing boards police the healthcare industry. The national database was supposed to help states identify dangerous doctors and prevent them from harming more patients, and is used by hospitals, insurers, and licensing boards to track doctors' records, check prospective hires, and make other decisions. But it is virtually useless in holding doctors accountable because, by federal law, none are listed by name. They are assigned a random number to protect their identities. Even if doctors were identified in the data as they should be, the public would still be barred by law from accessing the records. So vulnerable, sick patients sit in the waiting rooms of bad physicians without a clue about their poor record of performance. And in many cases, a negligent doctor's insurance company pays the victim of malpractice and the doctor goes back to work. If a doctor develops a bad enough reputation in one town, he can move to a new state and continue practicing. This is unbelievable. But today, the public does not have access to the database to identify doctors' names and addresses, to identify doctors with uniquely long histories of being sued or disciplined for medical malpractice. Because on September 1st, 2011, the government cut off public access. What was behind that decision? Apparently, one Kansas doctor with a trail of malpractice suits, Dr. Robert Tenny. The Kansas-based doctor complained to the Government Health Resources and Service Administration that the Kansas City Star newspaper was publishing the story of one of his patients, Maribeth Chase, who died in 2007 after undergoing a brain surgery with Dr. Tenny. It is also noted that Tenny has been sued at least 16 times for medical malpractice, but had never been disciplined by the state's licensing boards. The Insider Exclusive produced a TV story on this case with the lawyers who represented Marybeth's family when doctors go bad, Maribeth Chase versus Dr. Robert T. Tenny. Tenny finally settled the Chase family's wrongful death suit for $1 million. The settlement brought total malpractice payments paid on Tenny's behalf since the early 1990s to roughly $3.7 million. In some states, including California, Colorado, Georgia, and New York, patients can go to medical boards' websites to find out about doctors' malpractice histories, but not in Kansas and Missouri. Why don't doctors report on bad doctors? Physicians often see the mistakes made by their peers, which puts them in a sticky ethical situation. Should they tell the patient about a mistake made by a different doctor? Too often they don't. Why not? One reason is that doctors depend on each other for business, so a physician who breaks the code of silence may become known as an informer or snitch and lose referrals, a financial penalty. Doctors also may be wary of becoming entangled in a medical malpractice case or causing a colleague to face legal consequences. The bottom line, too often doctors aren't learning from errors, nor are patients getting the information they need to receive proper treatment or compensation when the outcome is harmful. Today, our Justice in America Network TV producer and host Steve Murphy sits down with some of Cunningham Bound's amazing lawyers, Brian Duncan, Robert Mitchell, and David Wortes, attorneys, who tried this case to jury verdict, which returned a unanimous verdict awarding $35 million in punitive damages against Springhill hospitals. And they will share the reasons for the hospital's incompetence and negligence, which led to John West Jr.'s unnecessary death. In 2014, then 59-year-old John West accidentally sliced most of the tip of his left thumb off when he was using a table saw in his shop. He went to the emergency room, at which he had surgery to suture the wound from the saw cut. He was given 2 pain medications for post-surgical care, Dilaudid and Percocet, the brand name for opioid oxycodone. He was admitted to the hospital following surgery for observation. He was given the prescribed pain medications while in the hospital. The hospital admitted prescribed doses of Dilaudid were administered to John, but Percocet was not. Jane Ellenwa, one of Springfield's nurses, at first denied giving John the daily dose of drugs, but was later proven to have lied. She testified at her deposition as follows. John was found unresponsive after the deadly doses of Dilaudid, and no drugs to counteract opioid overdoses were given, and he died. It was discovered that even though Narcan was available and defendant was billed for 5 units, the hospital never sought to use it, which would have saved John's life. And most amazingly, it was discovered that Springhill had no policy in place since 1989 for protocol to deal with dangerous opioids. That's how little they cared about their patients. Dr. Kenneth Rothfield, Chief Medical Officer and opioid patient safety expert, testified. Brian, Robert, and David have earned reputations as unyielding trial lawyers who repeatedly represent individuals and families against big companies and the Goliaths of the world and repeatedly win. And their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they most deserve. This is the Insider Exclusive, live from Mobile, Alabama. It is my great pleasure to introduce Brian Duncan to the show, as well as David Wortes. Welcome to the show.
Thank you. Good morning.
Brian, tell us a little bit about your firm. What does your firm do? What do they specialize in?
Yeah, I'm a partner at Cunningham Bounds, based in Mobile and Atlanta as well. Firm's was founded in 1958. We handle some of the largest and most important cases in civil litigation, from big commercial class actions. We're involved in the BP oil spill, but then also what they call single event, catastrophic, personal injury, wrongful death cases. So truck accidents, industrial accidents. I primarily focus on my personal practice on medical malpractice cases, where somebody has either died as a result of medical negligence or there's been some kind of catastrophic life-altering injury.
I have often found, having done many medical malpractice cases, that the lawyers who represent clients who are suing hospitals, healthcare workers, that kind of stuff, they must have gone to medical school to learn the terminology because you have to know it when you're cross-examining people.
You do. That's actually, I tell people that I spend a majority of my time actually studying the medicine that's involved. A lot of the law does change, but a lot of the legal concepts stay the same. The way that you take depositions may stay the same, but you have to learn whatever the medical procedure is or the medicine involved, which spends a lot of time, which makes you spend a lot of time studying the medicine, talking to experts, finding the best people. It's actually one of the reasons I think it's such a fascinating area of the law. My kids say nerd alert because I'm always liking to learn, but every single case I get to learn about a new, whether it's anesthesia, whether it's spine surgery, heart surgery, some type of other medical procedure that's unique, cardiac procedures, and it's a really fascinating area of the law. And while most of my friends are physicians, healthcare providers, and I think that our system is amazing, there are times when people make mistakes or they don't do the things that are appropriate under that circumstance. And there are some bad actors out there, and those people need to be held accountable. One, because you should be accountable, but then two, also to make it safer for everybody else.
And I know there are doctors who really want to apologize for mistakes to their patients, but what do their insurance carriers tell them to do?
You do have, obviously, different insurance carriers take different approaches, but traditionally medical malpractice insurers have taken a deny and defend approach to defending these cases. So even in cases that are the most obvious, egregious cases, I think we'll talk about one here in a minute. We're going to talk about the West case, where there's an obvious overdose. Those cases are litigated for years. They're fought with experts. You're forced to go to trial. You're forced to fight them on appeal. And so that's one thing that is different on medical cases. I think that people are surprised when they call our office and they talk to us, as I say, hey, it doesn't really matter how obvious this may be to people on the outside. This case is going to be litigated for years. Most likely you're going to go to trial, and we're going to have to prevail and convince 12 jurors, because the insurance companies defending healthcare providers generally take that position of deny and defend even the most obvious cases.
Yeah, and that's kind of a shame, because if we all did the right thing, right, David?
Yes.
There wouldn't be this unusually long road to get justice, correct?
I've been here 38 years. We've tried our medical negligence cases. I don't recall very many that have settled. In this case, we spent somewhere around $400,000 in West to bring it to trial and ultimate conclusion. And I think the overarching strategy that we encounter, at least, they want to make it expensive and difficult for us and hopefully dissuade us from taking cases.
Right, and they want you to quit. They want you to settle for next to nothing, which is really a disgrace, because if a doctor is incompetent, if a healthcare worker is incompetent, you don't want them anywhere near patients, right?
We don't want them near patients, but when doctors make mistakes, they've purchased insurance to provide coverage for that mistake. And more often than not, the physician wants the case settled.
You're involved in a lot of these cases from the very beginning as an appellate lawyer, looking for areas to avoid maybe having this go on appeal, correct?
Trying to avoid the issues ahead of time, but when they arise in the course of a trial, put out the fire and let's move on.
Tell us a little bit about your client, the one that's deceased right now, on a medical surgery that should have gone real smoothly, but problems arose.
Yeah, Jay, by all accounts, Jay West, 59 years old. He was semi-retired, but he was a craftsman. He had his own cabinet shop, woodworker, very well-respected, wonderful man, longtime husband, good father, everything that you would want to be, or to hope that someone would be. He ended up having a small accident at his cabinet shop, and he ended up with a table saw cutting just the, like, maybe top third of his thumb, just a little where he had hidden laceration. Ends up partially amputating his finger, but it's just a minor injury. So he then goes to the hospital, Springhill Hospital, and wraps it up himself. He gets there, no pain medication in the emergency room. I'm sure he's in pain, but he's a tough guy. He's a big guy. Over 6 foot, 6'3", 200 and I think 50, 60 pounds, big gentleman, and tough man. And so they didn't give any pain medication, but the doctor says that we're going to do a little surgery just to kind of finish the complete the amputation. It took 20 minutes. And then they decide that they will keep him overnight in the hospital just because it's late. They want him to have some IV antibiotics so he doesn't get an infection, and that he'll be fine to have some pain medicine if needed be. And everything went to plan. Actually, in the surgery itself, he only lost a teaspoon of blood, hardly any blood, short procedure. He, like I said, should have gone home. Unfortunately, that night, through a series of mistakes that really start with the hospital itself, but ultimately end with a nurse, he's administered 2 very large doses of Dilaudid, which is a highly powerful opioid pain medication that causes him to stop breathing, and nobody's monitoring him, and of course he expires that night.
So let me ask you a couple of things here. The nurse denied giving him this dosage first, right?
Jane Ellen, well, actually, she had left this hospital. She had gone to New Orleans, working another hospital in New Orleans at the time. We tracked her down after the litigation had begun, and of course we're taking her deposition, and she denied that she'd ever given the medication.
But that was a lie.
Yeah, we were able to show that it was. Obviously, we were able to have, the hospital has electronic systems, where Pyxis systems and audit records that you have to use biometrics to actually get this controlled narcotics out of the system. And we're able to prove that she actually did receive it and give it to Jay West.
I'm just curious, anything happened to her civilly or criminally as a result of this death?
No, she actually, herself, of course, the hospital's responsible for her, and she did not actually end up coming to trial herself. She did not show up. But I do want to make the point, because it's important, that why she made the ultimate error, the error started with this hospital. And the problem is, the root cause of this was the hospital had ignored an issue with opioid safety for decades. And that's why we ended up with the verdict that we did in the case. One of the things that's been a big problem in medicine for years is what's called opioid-induced respiratory depression. Patients, and certain patients, are more susceptible to this. These that are post-operative, ones that are heavier, ones that have obstructive sleep apnea, ones that have just had anesthesia drugs. And so for those patients, they were having patients that were receiving opioids. Because of the way the opioids, short version, interact with your brain, it can cause you not to breathe appropriately. Your respirations become depressed, particularly people who have sleep apnea, that normally we've all had the uncle or whoever wakes up and takes a breath when they choke. Well, the opioids prevent you from doing that. And so people's respiratory depression comes down and down. This had gone on through the 90s and the 2000s, and then in 2012, the Joint Commission for Hospitals, came out with a sentinel event, the only sentinel event alert they had that year, sentinel event number 49, and it instructed hospitals, hey, if you've not been paying attention to this problem with opioid-induced respiratory depression, then you need to do these things. And it bullet pointed out safety precautions to put in place, including protocols, pharmacy protocols, monitoring protocols, and training for the nurses. Springhill Hospital received that, passed that around via email we found out, to all their executives that mattered in the place, passed around their head of pharmacy, and they did nothing. And they sat on it, and they didn't implement, not some of the suggestions, they didn't implement a single recommendation. They ignored opioid safety, and as a result, this patient, Mr. West, came in there and was able to receive a massive overdose of opioids, have no monitoring from an untrained nurse, and what happened. And unfortunately, that was what this case was about, was not just some nurse who made a mistake. It was about a hospital and the system failures in that hospital that resulted in an unnecessary death of a patient.
What was the explanation by the hospital about not implementing any of these safety policies?
There wasn't an explanation. They acknowledged from the CNO to the director of pharmacy to the corporate representative, they were aware of the Sentinel event alert. They were aware of the foreseeable risk of harm, but they took no steps.
Yeah, the question is why? Why not?
We remain here today trying to understand why. What position they took in litigation was it wasn't their systemic failures that caused this. Rather, it was Jay West's time to die. He had an inexplicable arrhythmia.
Blame the deceased, right?
Correct, and they can find expert witnesses willing to back that up.
But in a autopsy, wouldn't it be more specific about spelling out that he died as a result of this, but because he was given a massive dosage? What did the autopsy say?
It's an important part of this case. There should have been an autopsy. The treating surgeon, Dr. McAndrew, requested one. The hospital policy required one.
There was an autopsy, I think you meant a toxicology report. There should have been a toxicology report. Complete with the autopsy, and it ended up there was no toxicology performed.
So really, there wasn't a complete autopsy then.
Well, and one thing that's important, and this goes back to the medicine involved in it, is that with an opioid-induced respiratory depression, even if he received this amount of drugs, it didn't poison him. He didn't just die because it poisoned him. What it caused him to do is he stopped breathing, and when he stopped breathing, then his oxygenation in his body eventually shuts down, which can happen very rapidly. Had he been hooked up to a continuous pulse oximetry monitoring, which is one of the technologies that's mandatory that the Joint Commission said you could have, that the Anesthesia Patient Safety Commission had said for years and before that, anybody involved in hospital safety, which is just a little device we've probably all had, you hook on your finger, and it would alert. Once his oxygen saturation started dropping, a nurse could have come in there and woke him up, said, Mr. West, take a breath. They could have given him a little bit of oxygen, he would have survived. And so this was a combination of they gave him enough opioids to make him stop breathing, and then no monitoring of the patient. And so while the toxicology would have been important, I believe my partner Robert, who you've had a chance to interview, had said that it was the failure to even monitor this patient that really caused it. Had he received an appropriate dose of drugs, the same thing could have happened because they weren't paying attention.
Why didn't they have this monitoring system? Was that in the special bulletin that went out to everybody?
It was, and actually in years before that, the Anesthesia Patient Safety Foundation had talked about it. They delayed. I don't really know why they delayed. Maybe it may have been a financial reason. They may have just not been paying attention. Right. But they delayed and did not buy the equipment or have the policies to use the equipment they did have available to monitor these patients. And so that was, part of, with this case it resulted in a large verdict. And the reason it resulted in a verdict is part of Alabama's very unique wrongful death law.
Yeah, explain that, please.
Every state has their own, to bring a case if somebody died, every state has their own various wrongful death laws. And what is associated with, there may be different ways to recover damages. There are two types of basic damages: compensatory damages to compensate somebody for the loss, and punitive damages. Alabama, and it's really, I will say, a biblical principle, and Dave can tell you exactly when it started, but it came up with a wrongful death statute that looks at not the value of somebody's life, but at the wrongful conduct involved. So the basic principle being all life is precious. Whether you are rich or poor, if you're a ditch digger or a neurosurgeon, all life is precious in Alabama. And so we're not going to get in and valuing, is Jay's West's life as good as Miss West's life, as my life, as your life, as Dave's. What we're going to get into is looking at how bad was the conduct that caused a death, and then we're going to hold people accountable for it. And then we're going to punish them for two purposes. One, they should be punished. And two, to prevent the future loss of life, to make things better. And so that's what this case was really about. It was one, hold Springhill Hospital for killing Mr. West, no question about it, and for the wrongful conduct that occurred here. But two, return a verdict to the jury that is going to make every hospital in the state of Alabama and others pay attention so that we can preserve future life, because this should not have happened. And so a big part of this case, why it ended up, was because of how reprehensible this hospital system was and just an absolute failure to have basic safety principles put in place.
Okay. You ended up getting a $35 million verdict.
We did.
Yeah. But it was later reduced. Why?
Well, I'll let Dave talk about the remittitor issues.
The circuit court judge, a very highly respected circuit court judge, thought in his judgment $35 million was too much given the precedents, prior reported wrongful death awards.
He was comparing it to other cases.
Didn't take issue with the reprehensibility of the conduct, didn't take issue with the righteousness of the claim or the sufficiency of our evidence. Rather, he thought it was too much given Alabama's history, which has been very conservative for generations.
But as Brian just mentioned, to send a message. Money hurts. I've done a lot of sexual abuse cases, and against, let's say, the Catholic Church, right? And the lawyer told me the only way to hurt them is with money. The only way they pay attention is with money. Doesn't that judge, that highly respected appellate judge, didn't he think about that too?
Well, the Alabama Supreme Court ultimately affirmed $10 million, and what you got to understand in the context of the history of the state of Alabama, that's the highest wrongful death award ever affirmed by our court. And it was unprecedented in the sense that the conduct was so bad, the hospital's decision-making was so reprehensible, that the court, in its judgment, determined that $10 million was the appropriate sum to punish this hospital and to deter this hospital and others in the state from not paying attention to sentinel event alerts in the future, from not implementing the necessary protocols required by the standard of care.
Here's a big question. What do you know about any changes, if there have been any changes, in protocol at Springhill?
My understanding is that they have adopted a lot of the things that they should have been doing at the time that we had this case that they did not. So
that's a positive thing.
Absolutely. I would say, and one thing I would be remiss, and I do want to say, one thing that gets lost sometimes and should never be lost, is the courage that it takes for somebody like Mrs. West to bring this case. Okay, Mrs. West is one of my favorite clients of all time. She's a wonderful human being. But it takes courage for an individual to come and stand up and to fight against a large hospital system, its insurers, its endless lawyers, its endless appellate lawyers, and fight for years when they're acting like you are the wrong person and the bad person for bringing this lawsuit. And her case has, and I hope the reason we're doing this now, is her case has had a wide impact in Alabama and elsewhere to make people aware of this issue, that opioid-induced respiratory depression is a serious issue, that hospitals have to take medication safety seriously, and that these kind of deaths should be prevented. And without courage of people like her, because nobody wants to be in litigation, nobody wants this to happen, nobody wants to bring a lawsuit, nobody wants to have to come sit in our office and talk to us about the worst thing that's ever happened to them or their family. And that is, the courage it takes, it cannot be understated.
I would add the courage of citizens who sit on juries and give us the time it takes to understand the evidence, to deliberate, to work together, to set aside their personal lives. The West opinion continues 3 years after it was returned to impact so many other cases in our state and in our country because 12 citizens of Mobile County had the courage and the patience to hear the evidence and decide what needed to be done.
When you say the courage, are you addressing the fact that if somebody knew who the jurors were, they would say, you just handed them a big check?
The hospital brought nurses and physicians into the trial day after day to sit them on the front row in their uniforms to try to bring pressure on the members of the jury.
Medical malpractice specialists, and thank God you do this work, because it's tough. What do you look for when people come to you and said, I have a claim against my doctor, against the hospital? How do you get through all of the, whatever they're saying to decide you're going to take this case?
There are, after doing this for almost 18 years, unfortunately, I had some mentors that were doing it before that, I truly stand on the shoulders of giants that mentored me on how to do this. But there are things that you look for, certain red flags, where surgeries are more like surgical malpractice more likely to happen on weekends, holidays, red flags that jump out at you. But we go through a thorough process of, it's not something that just jumps out at you right away. You first have to, you hear enough and say, well, that doesn't sound just right. And so then you go and you get the medical records, and then you've got to learn how to understand and review the medical records. And then our firm we have an in-house physician that looks at them from a medical standpoint, points out issues that he sees. And then we go and we find other experts. One of the things my partners and I and before us have developed some wonderful relationships with the best doctors at the best medical institutions in America. And I spend a lot of time with them, calling them just on the phone. Is this a case? Is this something that we should be involved in? And then also a lot goes into the person. I'm a firm believer we can only take so many cases. And when somebody like Miss West comes to me and I can tell that she is a true gem of a human being and that I want to fight for that client, and I want to spend my time, and she has a meritorious case, that's something that, we're willing to jump into, because our firm is very, very selective on the cases that we take. And we want to spend our time fighting for people that we truly not just believe in their case, but believe in them and want to help them. Because we'll become part of their family. We'll spend, we'll have dinner with them. They'll be here for years. These things aren't fast. And so I have a drawer in my office that's full of, the results. And on my wall is all the thank you notes and cards from my clients. So that's what motivates me, is helping somebody like Miss West get an outcome that without people like me or other firms or my partners that fight these kind of cases, she would never have had an opportunity.
Right. Well, I want to thank you both for being on the show, and great verdict. Great case.
Thank you.
Thank you.
It is my great pleasure to introduce Patricia West to the show. Welcome to the show.
It's so nice to be with you. Thank you for having me.
And we also have with us one of your lawyers, Robert Mitchell.
That's right.
Tell our audience a little bit about your husband. What kind of guy was he?
He was fun to be around. He loved to do things. He woodworked, but he built a car. He just loved to be busy. We went out with friends and had fun. Did family things together. We have 2 children, and we had finally had our first grandson, who was a little less than 2 at the time that I lost him. But life was always fun with Jay. He built cabinets, he built furniture, he welded things and put things together. You name it, he could do it.
The day and the incident that happened apparently cut off the top of his thumb.
Cut off the top. It was hanging by just a little piece. He called me. I was at work, and I left work, and I met him there, and he opened it up and showed it to me, and he said, "Look at this." I said, "I can't." He said, "I think they'll probably just snip that off." And but when we talked to the doctor, he said that if they did that, it would always be uncomfortable. But he wanted to take a little bit more bone to have covering, and so it wouldn't be tender. And so they did that surgery, which, everything was fine. He was fine. I went back to him in the recovery room, and we were talking, and then he looked at me, because he was always joking, and he said, "Oh, I'll never be able to play the piano again." And the nurse there was going, "Oh my goodness." And I said, "Don't listen to him. He's just playing with you." Yeah. But it was just a good time to be alive with him.
What went wrong?
Basically, they overdosed him on Dilaudid. I left the hospital at about 8:30 when we talked to the doctor. because my husband wanted to leave, and had this happened earlier in the day, he probably would have. But he said, I'd like to do a round of IV antibiotics because you cut your thumb on a table saw, make sure there's no problems. And you can leave first thing in the morning. So I left about 8:30 to get ready for the next day. And I got a call at 4:30 in the morning, and a nurse said the doctor would like to talk to you, the ER doctor. And he said, your husband stopped breathing, his heart stopped beating, he died. I woke up at 3:30 that morning with just kind of this fear. I'm thinking, everything was fine. Could he get a staph infection? Could something, this was before I knew anything. I think we were kind of telepathic with each other, because that was probably about the time that he stopped breathing. And so I had no idea what it was. And I was thinking, could it be an embolism? And I talked to the doctor about that, and he said, where the extremity and as far as it was, that would not cause an embolism. So we had an autopsy run, because I said I wanted an autopsy. I wanted to know, what happened to him, because he had been fine. He'd been joking and laughing even after it was over. So when I got the results of the autopsy back, I looked over it, and I didn't see anything that gave a precise reason. It did say heart failure due to coronary artery disease, but when I looked at the amount of clogged arteries, it wouldn't have been enough to give him a statin. It wouldn't have been enough to give him a stent. It was negligible.
You saw nothing about overdose.
Called my husband's cousin, Michael Wing, and he came over, and I had requested, and then I went and requested all the records from Springhill, and he came over and looked at that, and to me, I thought it was a lot. It was about, that thick. He had only been there from like 3:30 or 4 o'clock in the afternoon and died at 4:30 the next morning. I thought that looked like a lot of information. He said, this is not everything. And then they started looking at when he was given Dilaudid, and looking at, when the nurse had gotten it out of the Pyxis, when it had been delivered to him. And there were just a lot of, I think we discovered that even though she took one dose out at 8:30, she didn't give it to him until 10. And then when 3 hours was up from the 8:30, she took another dose out and immediately gave it to him. So he got 2 doses in an hour and a half.
Robert, obviously these facts jumped out at you, right? Jumped out at the firm and say, hey, this is an overdose.
Absolutely. And the thing about Dilaudid that is important to understand is that it is roughly 7 to 8 times as potent as morphine. So giving a patient 1 milligram of Dilaudid is akin to giving the patient 7 milligrams of morphine. And through a careful review of the medical records, including the audit trail, we were able to determine that she had given Jay 2 doses of Dilaudid within a roughly 4-hour window. And the amount of Dilaudid that had been administered to her, according to a number of the treating physicians who were deposed, was egregious. It was insane. The words used to describe it were certainly...
She basically killed Trisha's husband.
There's no question. It was a massive frank overdose. The amount of Dilaudid that was administered to Jay during that window, 2 doses of 4 milligrams, a total of 8 milligrams, is like giving a patient 56 milligrams of morphine. And on top of that, really the key to the case was not only the fact that they administered the medication, but that Springhill Hospital didn't have in place any real monitoring protocols. And these are protocols that, for example, the Joint Commission had indicated were appropriate since 2014. And you can look at medical and nursing literature going back to really the early 1990s, identifying opioid-induced respiratory depression as a serious fatal risk. So even if the nurse had administered an appropriate amount of the medication in an appropriate time frame, the hospital still didn't have in place the policies, the procedures, the safety net to protect not only Jay, but every other patient that walked into the hospital.
And I'm just curious, Trish, was your husband complaining about pain after the surgery?
No.
Did he need these drugs?
He came back to the room about 7 or 7:30, I would say, and for the hour that I was there, he wasn't having any pain then. And like I say, I left at 8:30, but I did call him on the phone after that, and he was okay.
What do you think about the masterful work that Cunningham Bounds did for you and your husband?
I don't think there's anyone else who could have handled this case the way Cunningham Bounds did. I was so appreciative. They kept me informed of everything that was going on. They looked at everything upside down, inside out, and I couldn't be more pleased. I don't know where we would be without them.
Well, thank you very much for being here.
Thank you so much for having me.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.